Good morning, Madam Ani. My name is Chyi En with matrix number of 244388. Today, what I'm going to present will be the case review of Wong Fo Hin versus PP. So first of all, I'd like to make a brief introduction on what is character evidence. So character evidence actually refers to a person's conduct or his previous act. It can either be internal or external. Internal actually refers to a person's disposition, where how he actually behaves naturally or his inner qualities, while external refers to his reputation among other persons on how he actually acts. Section related to character evidence will be from Section 52 to Section 55. Section 52 and Section 55 is related to the admissibility of character evidence in civil cases. The general rule is that both bad and good character evidence cannot be admissible in civil cases. However, in criminal case, the section related will be Section 53 and 54, and the general rule is that good character evidence can be admissible, but bad character evidence cannot be admissible, but there's also exceptions provided. Good character evidence in general is admissible in order to know the credibility and also the tendency of accused in committing the crime. On the other hand, bad character evidence is not admissible in general, as the aim of trial is to try the case and not the man, and it is prejudicial. Now, I'm going to talk about the facts of the case. The appellate was being convicted to murder his daughter, and such conviction were due to the court reliance on two main evidence. The appellate counsel then appealed and contend that these two evidence shall not be admissible as amount to bad character evidence. The first evidence in question is when the appellate's wife complained to village headman that appellate interfered his daughter. The village headman settled this matter by warning appellate that if same thing repeated, they'll report to the police. The second evidence in question is the similar incident suggesting an incestuous relationship between the appellate and his daughter occurred again, and when the appellate noticed that the wife aware of such incident, he shut the wife out of the room door and left he himself and the daughter alone in the room. Knowing that something has happened, the wife then go and report to the police. When the police reached the house, they found that the daughter was missing, and 2 days later, the daughter's body was then found in a well near the house. The issue in this case is whether both evidences adduced by prosecution has amounted to bad character evidence under Section 54 of Evidence Act 1950 and was therefore inadmissible. Federal Court then upheld the decision of trial judge and held that the evidence of both incidents were admissible. There are two main grounds which the court rely on in making the decisions. The first is the evidence shall not be inadmissible merely because it tended to show bad character of the accused. The second ground would be there is no any direct evidence in this case. So, as both of the evidence are strong evidence of motive with high evidential value, thus the court opined that it shall be admissible. The court has also referred two main authorities. The first one will be Indian authority, the Book of Monier. In this book, it has stated that an evidence of motive shall not be irrelevant merely because it has accidentally disclosed the bad character of accused. The second authority which the court refers to is the case of McKean, where the court has actually held that a bad character evidence shall not be inadmissible if it is relevant to the issue of the case or if such alleged act has shown the crime charged against the accused were designed or planned by the accused. Next would be my reflection on this case. In my opinion, I do agree with the decisions of Federal Court which has stated that even if the evidence tend to show bad character evidence, but it shall be admissible. There are three reasons for my opinion. First is referring to Section 8, where it stated that any facts that shows motive of accused in committing the crime shall be admissible. Second reason will be, as referring to Section 11 of Evidence Act, it has stated that facts originally not relevant can be relevant if it by itself or in connection with other facts has shows existence of facts in issue. For the third reason will be, I opine that both of the evidences were clearly the strongest possible evidence of motive, so it must be admissible. Now, I will explain on why I think both of the evidences shows the motive of the accused. For the first evidence, we can know that the accused has received a strict warning from the village man and wife that if he have ever found to interfere with his daughter again, they will report to the police, which means he will be punished for what he has done, and this is clearly a threat to him. Or for the second evidence, the appellant once again interfered his daughter, and this was then found out by his wife. The fact that after his wife found out such incident, she went off during that time. The appellant most probably aware that his wife is going to report to police as due to the warning in first evidence. Knowing that his daughter will be the material witness for the police and will cause the threat to him to be convicted for crime of rape, he knew that his daughter must not be found by police to prevent any conviction against him. So from here, we can see that it is indeed a very strong and convincing evidence in showing the motive and intention of the accused to murder his daughter to prevent any charge or conviction on him. Moreover, I've also referred to a case of Chyi En, where the court has held that bad character evidence can be admissible if its probative value has outweighed its prejudicial effect. So, I think that since both of the evidence has adduced strong and convincing motive of the appellant in murder his daughter, it is difficult not to agree that the probative value of these two evidence has outweighed its prejudicial value, so these two bad character evidence shall be admissible. Other than that, I've also learned that acts shall be read as a whole before applying any section, as we can see that in this case, although it was stated under Section 54 that we should not admit bad character evidence. However, when we relying on Section 8 and Section 11b of Evidence Act, we knew that bad character evidence can still be admissible if it amounts to motive or if by themselves or in connection with other facts, it make existence of any facts in issues. So that's all from me. Thank you.